The following video excerpt is taken from a recent edition of Financial Management Network, a production of SmartPros.
Earlier this year, a federal court in New York ruled that Fox Searchlight violated both minimum wage and overtime labor laws by not paying the interns for the work that they did while on the set. It is a legal precedent that has already seen intense debate and more legal filings. Does this mean that the unpaid internship is dead?
With us to answer that question and many others is Nikki Nesbitt, a partner with the firm of Goodell DeVries, where her practice concentrates on commercial and employment law. Thanks for joining us this month, Nikki.
Yeah, this is something that has been really brewing for quite some time. You know, the law hasn't changed much on unpaid internships, but the attention to the subject has certainly changed greatly in the past couple of years. And we recently had a decision handed down in New York that got a lot of attention and has a lot of plaintiffs' firms sort of buzzing about getting class actions together on behalf of unpaid interns. Essentially, the question becomes, is a person who is serving in an internship an employee, in which case they're subject to certain wage and hour requirements that the employer has to follow? Or are they truly a volunteer who is there for their own education, in which case it's okay to be doing an unpaid internship? And there's a lot of controversy about what it takes to establish a real unpaid internship as opposed to a position that really should be paid but isn't.
According to a recent survey, nearly one-half of the 30,000 interns surveyed reported that they worked without pay. Now, from your perspective, Nikki, how knowledgeable are employers, such as your clients, about this law?
I think that employers are certainly becoming more knowledgeable as the issue gets more attention in the media and in the court system. The 6 factors that the Department of Labor came up with really are designed to focus the issue on whether an internship is really for the benefit of the intern or is it really for the benefit of the employer. That's the distinction that those factors are really designed to address. And so as you go through them, you see that the Department of Labor is asking these employers to consider, is this the kind of position that resembles an educational experience like what you would see in a classroom or a vocational setting? Is this more for the education of the employee, or is the employee really doing some tasks that are for the betterment of the employer? Is this person replacing someone who would otherwise be hired for that position?
Now, I'm curious, what should our viewers and their companies be doing? What are you advising your clients to do?
Well, you know, Mike, our clients ask that question a lot. We do get questions about whether unpaid internships should be considered or whether they should just be thrown away. And what we tell our clients is that you really need to consider what you're having these interns do. You really need to look at your criteria and what you're looking for in an intern to decide whether maybe you should be paying those individuals or having your existing employees do that work for you. So, you know, it really just takes a close, cautious eye to decide whether your internship program can really continue under the current legal status.